I have sat on this bench for 39 years. I have heard institutions deny people benefits for reasons ranging from legitimate clerical errors to the kind of bureaucratic indifference that should embarrass everyone responsible for it. I thought after 39 years that I had heard every version of an institution failing to see the person standing in front of it. On a Monday morning in June, I learned I was wrong, because what happened in my courtroom that day was not simply an institution failing to see a person. It was an institution that had spent 70 years refusing to believe a woman's own account of her own life, simply because the official record did not match what someone decades earlier had decided was possible for a woman to have done. Her name was Dorothy Kessler. She was 87 years old, and the moment she sat down across from me, before a single word of testimony had been spoken, I understood that I was looking at a woman who had spent most of her adult life being told that her own memory of her own service did not count. My name is Judge Judy Shaindlin. This is the story of Dorothy Kessler, and this is the morning a system that had doubted her for 70 years finally had to listen. Dorothy Kessler had enlisted in the United States Army Nurse Corps in 1951 at the age of 22. She had been a registered nurse for 2 years at that point, trained at a hospital school of nursing in the Midwest. And when the call went out for nurses to serve in Korea, she had volunteered within the first week against the wishes of her father, who had told her that nursing in a war zone was no place for his daughter, and with the full support of her mother, who had said simply that Dorothy had always known her own mind and was not about to stop now. She had served for 18 months, the majority of that time at a mobile Army surgical hospital, located close enough to the front lines that the sound of artillery was a constant backdrop to every surgery, every triage decision, every long night spent trying to keep wounded young men alive long enough to be evacuated to better facilities further from the fighting. She had worked alongside surgeons in conditions that, by any modern medical standard, would be considered barely adequate. She had held men's hands as they died. She had assisted in surgeries by lantern light during power failures. She had contracted a respiratory infection during her second winter there that had left permanent scarring on her lungs, a fact that would become relevant decades later in ways she could not have anticipated. She had come home in 1953, married 2 years later, raised 3 children, and worked as a civilian nurse for another 31 years before retiring at the age of 58. She had rarely spoken about Korea. Like many of her generation, she had simply folded that period of her life into a private compartment and moved forward, carrying it quietly rather than displaying it, because that was what her generation had been taught service looked like. The case that brought her into my courtroom that Monday morning concerned a denial of veterans' benefits, specifically a disability claim related to the chronic respiratory condition that Dorothy's physicians had 2 years earlier, formally connected to the lung scarring she had sustained during her service in Korea. The claim, if approved, would have provided both a modest monthly disability payment and access to specialized pulmonary care through the veterans' health care system, care that Dorothy, on a fixed income, had been struggling to afford on her own for the better part of a decade. The claim had been denied twice by the Regional Veterans Benefits Office, and Dorothy, with the help of her granddaughter, a 34-year-old paralegal named Caroline Ashworth, who had taken on her grandmother's case with the particular fierce dedication of someone defending a person she loved, had pursued the matter through every available administrative appeal before finally filing suit in civil court against the Regional Benefits Administrator, a man named Gerald Finch, who appeared that morning representing the agency's position alongside a government attorney named Patricia Voss. I opened the file. This case involves a disputed denial of veterans' disability benefits for Dorothy Kessler, relating to a service-connected respiratory condition allegedly sustained during her service as an Army nurse in Korea between 1951 and 1953. Mrs. Kessler, can you tell the court about your service? Dorothy's voice, when she began to speak, carried the particular steadiness of someone who had told this story to skeptical officials enough times that she had learned to tell it plainly, without embellishment, because embellishment, she had learned, was simply something for people to seize upon as evidence she was exaggerating. She said, "Your Honor, I enlisted in the Army Nurse Corps in 1951. I served 18 months at a mobile Army surgical hospital in Korea, primarily during the periods of heaviest fighting near the 38th parallel. I assisted in surgery, managed post-operative care, and provided what comfort I could to young men who were, in many cases, only a few years younger than I was at the time. She continued, during my second winter there, I contracted what was diagnosed at the time as a severe respiratory infection. I was treated as best the facility allowed and returned to duty within 3 weeks because we did not have the luxury of extended medical leave when the patient census never stopped growing. I have experienced chronic respiratory symptoms, increasing in severity, for the majority of my adult life since. I turned to the government's representative. Mr. Finch, what is the basis for the agency's denial of this claim? Gerald Finch consulted his file and said, Your Honor, the agency's position is that Mrs. Kessler's official service record does not contain documentation of the specific respiratory illness she describes, nor does it contain medical treatment records from the period in question establishing a clear service connection between any documented condition and her current pulmonary diagnosis. I looked at the file before me. Mr. Finch, is the agency disputing that Mrs. Kessler served in Korea as an Army nurse? He said, no, Your Honor. Her basic service record, dates of enlistment, deployment, and discharge is confirmed and not in dispute. I said, then the dispute is specifically about whether the respiratory illness she describes is adequately documented within that confirmed service period. That is correct, Your Honor, Finch said. The agency requires medical documentation contemporaneous with the claimed injury or illness in order to establish service connection, and our review of the available records from the field hospital where Mrs. Kessler served did not locate documentation specifically matching her account. I turned to Caroline Ashworth, who was seated beside her grandmother with a thick binder of her own. Miss Ashworth, I understand you have done significant research into this matter. Can you explain to the court why documentation from this specific period might be difficult to locate? Caroline stood, and I could see in the careful, controlled way she organized her opening words that she had clearly rehearsed this explanation many times, likely in front of agency officials who had not wanted to hear it. She said, Your Honor, my grandmother's field hospital was located in a combat zone subject to repeated relocation and, on at least 2 documented occasions, direct enemy fire that damaged hospital facilities. Administrative record keeping under those conditions was, understandably, not always complete or properly preserved. The National Archives has confirmed that significant portions of medical records from several mobile Army surgical hospitals operating during this specific period of the Korean War were lost, damaged, or never adequately filed in the first place due to the chaotic conditions under which these units operated. I asked her to continue. She said, what we do have, Your Honor, is a unit roster confirming my grandmother's assignment to that specific hospital during the exact period she describes, a partial morbidity report from the facility covering a 3-week period that winter, showing an outbreak of respiratory illness among medical staff, though it does not list individual names, and a letter my grandmother wrote to her mother during that period, which my great-grandmother kept her entire life and which has been in our family ever since, describing in real time the illness my grandmother was experiencing while it was happening. I asked to see the letter. Carolyn produced it, carefully preserved in a protective sleeve, the paper visibly aged and fragile, the handwriting unmistakably that of a young woman writing under difficult conditions, but with clear and legible penmanship. I read it into the record, paraphrasing where the paper was too fragile to be certain of every word, but preserving the substance. The letter described, in Dorothy's own words, written in January of 1953, a persistent cough that had developed into difficulty breathing, fever that came and went over several weeks, and her continued work despite these symptoms because, as she had written to her mother, the boys here need us more than I need rest. The letter was dated, signed, and referenced specific events that historical records independently confirmed had occurred during that exact window at that exact location. I set the letter down carefully. Mr. Finch, the agency's position is that this letter, combined with the partial morbidity report and the confirmed unit roster, does not constitute sufficient documentation of service connection. Gerald Finch said, Your Honor, the agency's regulations require, where possible, official medical documentation rather than personal correspondence, however compelling. Personal letters are not considered reliable medical evidence under our evaluation standards. I said, Mr. Finch, you have just told this court that the agency's own records confirm that official medical documentation from this specific hospital during this specific period was frequently lost or never properly filed due to combat conditions. Is that correct? That is correct, Your Honor, Finch said. So the agency's position, I said, is that despite acknowledging the documented unreliability of official records from this exact circumstance, the agency continues to require precisely the kind of documentation it knows, by its own admission, is unlikely to exist for someone who served exactly where and exactly when Mrs. Kessler served. Finch paused. Your Honor, the regulations are designed to ensure consistency in claims evaluation across all applicants. I am not in a position to make exceptions to documented requirements based on individual circumstances, however sympathetic. It was at this point that something shifted in the proceedings, and it came not from Gerald Finch, who had at least maintained a posture of bureaucratic neutrality throughout, but from Patricia Voss, the government attorney seated beside him, who had been largely silent until this moment and now leaned forward to add what she apparently considered a clarifying and helpful point. She said, Your Honor, if I may add some additional context that I believe is relevant here. Frankly, claims like this one present a particular evidentiary challenge because women's roles in combat zone hospitals during this era were often informal and undocumented in ways that male combat records simply were not. Quite honestly, Your Honor, official military culture at the time did not always take the same care in documenting the experiences of female personnel, in part because, candidly, women didn't serve in the same officially recognized combat-adjacent capacities that generated the kind of rigorous documentation we typically rely on for these determinations. She said it smoothly, professionally, clearly believing she was offering useful institutional context rather than revealing something far more damning. She had no idea in that moment what she had just said or to whom she had said it. The courtroom went completely silent. Caroline Ashworth's hand, which had been resting on the table, curled slowly into a fist. Dorothy Kessler sat very still, her composed expression unchanged. But I watched something settle behind her eyes, the particular focused stillness of a woman who had heard some version of this sentence many times across 70 years and had never once let it go unanswered. I looked at Patricia Voss for a long moment. I said, Miss Voss, I want to make sure I understand precisely what you just told this court. Are you suggesting that women, as a category, did not serve in combat zone medical facilities during the Korean War in a capacity that would have generated reliable documentation? Patricia Voss, apparently still not recognizing the size of what she had just stepped into, said, Your Honor, I am simply noting that institutional record-keeping practices of that era often reflected broader cultural assumptions about women's roles, and that this historical context is relevant to understanding why documentation gaps exist more frequently in claims involving female veterans of this period. I set down my pen. Miss Voss, I said, Dorothy Kessler is sitting in this courtroom right now, 87 years old, having served 18 months at a mobile Army surgical hospital that was, by your own agency's acknowledgement moments ago, subject to direct enemy fire. She held the hands of dying soldiers. She assisted in surgery by lantern light. She contracted a respiratory illness severe enough to leave permanent scarring on her lungs, a condition her own physicians have formally connected to her service. And you are telling this court that the reason her documentation is incomplete is essentially that the institutions of her era did not consider women like her worth properly documenting in the first place. Patricia Voss began to respond. Your Honor, I did not mean to suggest that her service was not real, only that the record-keeping standards of the time where I held up one hand. Miss Voss, I do not need you to clarify your intent. I need you to sit with the substance of what you just said, because I think it explains more clearly than any agency regulation could exactly why Dorothy Kessler has spent 70 years fighting to have her own service recognized. You did not just describe a historical documentation gap. You described in real time the exact institutional attitude that created that gap in the first place. And you described it as though it were simply a neutral fact of history rather than an active injustice that this court has the power to correct today. I turned to Dorothy. Mrs. Kessler, I want to ask you something directly. In your 18 months in Korea, did you ever doubt that the work you were doing was real, was difficult, and mattered as much as anyone else's service in that conflict? Dorothy's answer was immediate, her voice steady and clear. Your Honor, I never doubted it for a single moment while I was there. The doubt came later, every time I sat across from someone in an office who looked at my file and seemed to need convincing that an 18-year-old nurse holding a dying boy's hand while artillery shook the walls around her was somehow doing something less significant than what was happening on the front lines 15 miles away. I have spent 70 years being asked to prove something I lived through with my own body and have never once forgotten, simply because the people writing down what happened in 1953 did not think a woman's account was worth writing down carefully. I stood up from the bench. Here is my ruling. This court finds that Dorothy Kessler has presented sufficient and credible evidence of service connection for her chronic respiratory condition. That evidence consists of confirmed unit deployment records placing her at the exact hospital during the exact period in question, a partial morbidity report independently corroborating a respiratory illness outbreak among staff at that facility during that winter, and a contemporaneous personal letter written in real time during the events described, whose content is fully consistent with both the historical record and her current medical diagnosis. I am ordering the Veterans Benefits Agency to immediately approve Dorothy Kessler's disability claim, retroactive to her original filing date 6 years ago, with full back payment of all benefits she should have received during that period, calculated at the standard disability rate applicable to her condition. I am further ordering that her case be flagged for the agency's record as a precedent for the evaluation of similar claims from female veterans of this era, where official documentation gaps reflect known historical deficiencies in record keeping rather than any deficiency in the veteran's actual service or credibility. I am also formally referring the substance of Ms. Voss's testimony today to the agency's regional director, with a recommendation that this case be used as a training example in evaluating institutional bias in claims processing. Because what was articulated in this courtroom today, however unintentionally, represents exactly the kind of thinking this court believes has unjustly delayed and denied benefits to women like Dorothy Kessler for far too long. Patricia Voss sat very still. Gerald Finch was writing quickly, his earlier bureaucratic composure now replaced by the visible recognition that the morning had not gone the way either of them had expected. I turned to Dorothy. Mrs. Kessler, do you have anything you would like to say before we conclude? She was quiet for a moment, her hands still folded in her lap. Then she said, Your Honor, I want to say something not just for myself, but for every woman who served in a war and came home to find that her service somehow needed to be proven in a way that the men beside her never had to prove theirs. We were there. We did the work. We carried what we carried, the same as anyone in uniform, and I would like, before I am gone, for that simply to be believed the first time without 70 years of asking. I looked at her. Mrs. Kessler, this court believes you. It always should have, and I'm sorry it has taken 70 years for an institution to say so plainly. 6 weeks later, I received a letter from Caroline Ashworth. The back payment, calculated across 6 years of retroactive benefits, had arrived, totaling just over $41,000. But Caroline wrote that the money, while meaningful, was not what her grandmother talked about most in the weeks following the ruling. What Dorothy talked about, Caroline wrote, was the moment in the courtroom when someone in an official capacity had finally said the words, "This court believes you," out loud, in a room, on the record, After 7 decades of being asked in one bureaucratic form or another to prove it all over again. Caroline wrote that her grandmother had taken the old letter, the one she had written to her own mother from Korea in 1953, and had it professionally framed, and had hung it in her living room where she could see it every day. Caroline wrote that Dorothy had said, looking at that letter on her wall, that she finally felt as though the 18-year-old nurse who wrote those words and the 87-year-old woman reading them now were, for the first time in a very long time, fully the same person, fully believed, fully whole. I keep that letter from Caroline in my desk now, beside so many others. Dorothy Kessler held dying boys' hands in a war zone 70 years ago and came home to spend the rest of her life being quietly doubted by institutions that had never once stopped to ask her directly what she had lived through. On a Monday morning in June, in my courtroom, someone finally asked, and finally, completely, she was heard. That is what this bench exists to do, not simply to apply the law, but to make sure that 70 years of being doubted ends decisively the moment the truth finally has a room willing to listen to it.